Welcome to Diagnosing Health Care, a podcast featuring thought-provoking conversations about the latest legal, policy, and regulatory issues in healthcare. While these issues may seem like hurdles, we'll also look at the business opportunities and solutions that exist. Diagnosing Healthcare is brought to you by the healthcare lawyers at Epstein, Becker, Green, a leading law firm that has more than 40 years' experience serving clients in the healthcare industry nationwide.
Today on Diagnosing Healthcare, we discuss the good faith estimate requirement and the patient-provider dispute process under the No Surprises Act. Hello and welcome. This is Alexis Boaz hosting an episode of Diagnosing Healthcare. I'm an attorney in Epstein, Becker, Green's healthcare and life sciences practice based out of our Washington, D.C. office. Over the past few months, the Biden administration has released a series of interim final rules, proposed rules, and guidance to implement the No Surprises Act, which went into effect January 1st. While some providers might think they're safe from the No Surprises Act or the NSA, due to the nature of the services they perform not fitting within the context that triggers the balanced billing prohibitions, all providers and facilities should be aware that the NSA includes a few surprise provisions that apply more broadly to all providers and facilities, regardless of whether the provider or facility may be subject to the NSA's balanced billing prohibitions. Specifically, starting January 1st, all providers and facilities must provide a good faith estimate to uninsured and self-pay patients scheduling appointments for services or upon request. Providers or facilities that bill substantially in excess of the good faith estimate may be taken to the patient-provider dispute process by the patient. On today's show, we're going to discuss the good faith estimate, what it entails, who needs to provide it, and updates regarding enforcement. Additionally, we'll talk about what substantially in excess means and how the provider-patient dispute process works. If you like what you hear today, please subscribe to the show. Diagnosing Healthcare is available wherever you get your podcasts. Today, Helaine Fingold and Bob Hearn are joining our discussion. Helaine Fingold is a member of Epstein, Becker, Green in the Baltimore office. She had significant previous experience with the U.S. Department of Health and Human Services, and now, in addition to advising many other types of clients, has been spending a great deal of time delving into the NSA to help clients in the health plan industry understand and comply with the requirements of the NSA. Bob Hearn, a member of Epstein, Becker, Green in the St. Petersburg office in Florida, is also joining us. He has a wealth of knowledge and years of experience advising in the clinical laboratory space. He's also done some deep dives into the NSA to advise clinical labs to comply with the new law. Welcome and thank you both for joining.
Thanks, Alexis.
Thanks, Alexis. Good to talk to you about this.
I'll give an overview of the good faith estimates. The NSA actually includes two good faith estimates, one that applies to covered patients and one that applies to self-pay and uninsured patients. In some guidance that the departments released, the departments noted that the good faith estimate for covered patients would not be enforced until the departments completed further rulemaking and in order to allow providers, facilities, and plans more time to coordinate their ability to share information. Under that framework, an insured patient would schedule an appointment or could request a good faith estimate. The provider or facility would provide the good faith estimate, which would go to the plan. The plan would use that good faith estimate to put together an advanced explanation of benefits. As I stated, that portion of the law has been deferred. However, all providers and facilities must give a good faith estimate to uninsured or self-pay patients starting on January 1st, 2022. Patients will also be able to enter into the patient-provider dispute process based on these estimates on January 1st as well. So let's get started with the good faith estimate. As I mentioned, the good faith estimate for covered patients has been deferred. Who will be able to get a good faith estimate starting January 1st?
So starting January 1st, the good faith estimate requirement applies to technically the uninsured, but that would include individuals that have no coverage, certainly, but it would also apply to self-pay patients. So people who perhaps have coverage, but have chosen not to have a claim submitted for the service. It could also apply to individuals who may have benefits, but not benefits that sort of qualify as group health coverage or individual health coverage under the ACA. So if you had a limited benefit or short-term coverage, those wouldn't qualify as coverage. So those individuals would be eligible for the good faith estimate for the uninsured.
Great. And which providers and facilities will be required to provide these good faith estimates?
So this is fairly broad. It would apply to facilities and providers that may not be impacted directly or significantly impacted by no surprises, and seems to apply to any provider or facility that takes appointments. And therefore, if somebody makes an appointment, that provider or facility would have to give the patient, if the patient is under the coverage, group health coverage, or a federal benefits program, then the provider would have to give that person this good faith estimate.
Great. And so some of the facilities that the rules list include critical access hospitals, ambulatory surgical centers, rural health centers, federally qualified health centers. So as you mentioned, it's a lot more broad than the rest of the NSA balanced billing protections. And when must the providers or facilities provide the good faith estimate?
So the timing of giving the good faith estimate depends on whether a provider or facility is giving it based on a request or based on a scheduled service. As Helaine noted just a minute ago, one of the ways that the obligation to provide a good faith estimate to a patient is triggered is when a service is scheduled with a facility or a provider. If a patient schedules a service at least 3 business days in advance, then that facility or provider has to give the good faith estimate in 1 business day or less after the date of scheduling. When a service is scheduled with a facility or provider at least 10 business days in advance, then the facility or provider has to provide the good faith estimate to the patient in 3 business days or less after the scheduling. Again, we're talking about just uninsured and self-pay patients here. When those types of patients request a good faith estimate from a provider or a facility, then the estimate has to be provided within 3 business days or less after the request is made, and at least 1 business day in advance of the date that the service is delivered. So that's the basic time frame for getting a GFE, depending on whether the estimate is requested or is given as a function of a scheduled appointment.
Great. And how does this work in practice? What are providers and facilities required to do?
That's a really good question. And the way in which the GFEs are going to be given can, I think, ultimately be a little bit tricky for facilities. It can be given in a couple of different ways. It can be given either by mail or by electronic transmission. So there's different methodologies that are available, but generally they're going to have to be triggered again by this scheduled appointment or a request. And I think the thing that's going to be difficult and challenging for providers and facilities here is figuring out whether the patients that schedule appointments with them are actually uninsured or self-pay. It's a piece of information that's going to have to be collected either when a patient calls a provider to schedule a test or a facility to schedule a test, or makes a test using an online payment platform. They're going to have to collect the information, then they're going to have to be able to process it and make a determination as to what it is the provider or the facility has to tell the patient. Moreover, there is an obligation on the part of providers and facilities to ultimately provide a good faith estimate when a patient asks about cost during a customer service telephone call. So for instance, if a patient were to call a provider or a facility and they don't specifically request a good faith estimate, but they mention that they're curious about the price of, let's say, a laboratory test or an imaging study that's been ordered, that inquiry alone has to be construed as a request for a good faith estimate. At that time, if the provider wants to give the patient information verbally over the telephone, they're permitted to do that, but they don't have to do it. And even if they do give the patient information relating to the anticipated cost of the service verbally, they still have to provide them with a good faith estimate in writing, as though the patient specifically requested it.
Great. And let's dive more into the elements of the good faith estimate. And to clarify, this good faith estimate is different from a good faith estimate that might be required when a patient consents to being balance billed for out-of-network services under the traditional NSA balance billing prohibitions. The content requirements of this good faith estimate for self-pay and uninsured patients is much more detailed. Could you discuss some of the elements that would be required?
So the regulatory requirements of the good faith estimate that has to be given upon scheduling a service or a request are set out in the interim final rules supporting the No Surprises Act. And again, as you mentioned, they are detailed and fairly routinized. The provider or facility has to include the patient's first and last name in the request, their date of birth, It has to include a description of the primary service or item requested or scheduled to be performed. And then it has to include any sort of diagnostic codes associated or test codes associated or service codes associated with the service that's been scheduled or requested. For instance, if you're a lab, you'd have to provide the CPT code for the test that is being performed on the patient, either by virtue of it being scheduled or the patient requesting information about a particular service. Another challenge is going to be that the rules require the provider or the facility to include any diagnosis code associated with the service that they're going to be provided. And I think that's, as we can discuss later, going to be a little bit tough for patients and providers to sort of work out between themselves when they're discussing the possibility of a GFE. The date on which the primary service or item will be provided by the facility or provider has to be included in the good faith estimate. The primary provider's NPI number, as well as their tax identification number, is supposed to be provided on the good faith estimate, and where the services will be provided, which again is another tough issue for ancillary service providers who might be operating regionalized labs in different locations. And it will be sort of unknown at the time that a test is scheduled exactly where the analytical work is going to be done. The other context in which I imagine difficulty here is in the teleradiology segment, where you might have radiologists sitting in numerous different places rendering substantive diagnoses on imaging that's performed in one particular location. And then obviously there has to be a total estimated cost of the service that's going to be provided to the patient in the good faith estimate. That's arguably the essential and critical element of the GFE itself. The rules go on to set out a number of disclaimers that the good faith estimates have to entail. Basically, they have to remind the patient that the good faith estimate is exactly what it calls itself. That is, it's an estimate, and that prices can actually change, that the services that are offered to the patient might be different from those that are outlined in the GFE to the extent that clinical conditions or the patient's condition warrant it. They have to tell the patient that the good faith estimate does not constitute a contract and imposes no obligation on the patient to obtain the service from the provider or facility that issues it. And it has to give a basic synopsis of the patient's rights to challenge the charges that are ultimately rendered to the patient to the extent that they are substantially greater than those included in the good faith estimate.
Great, thank you. And another component of the good faith estimate that's actually been deferred would be the estimate from co-providers and co-facilities. Could you discuss that a bit?
So the co-providers and co-facilities, those are situations when somebody is getting a service, receiving services, and perhaps there's multiple aspects. So perhaps there's a lab service that they're getting on one side and they're getting a test, some sort of another diagnostic test. And there's generally what they call a convening provider. So this is the facility that schedules the service, that sort of global, the overall service. What the law envisions is that person, the law, the regs envision that person will be in charge of gathering the information about the services that are part of the procedure or total service the person's receiving. And then we'll have to be responsible for getting the estimates for all of the pieces of those services and putting those together into the good faith estimate. However, for 2022, the departments have said that they won't find the convening provider or facility out of compliance if the good faith estimate does not include all of the co-providers' estimates, because right now there's question as to how the information will get conveyed. And so they're holding off on that requirement, but the departments are encouraging the co-providers to make an effort to get that information to the convening provider. But again, it's not something that's going to be enforced at this point.
Great, thank you. And you discussed some issues about the information exchange. What are some other issues you foresee with this good faith estimate?
I mean, I think ongoing issues that arise in other ways and other pieces of the implementation of No Surprises, and the coordination is a problem. Do the providers have the staffing and the processes in place to put together this information, particularly on the tight timeframes that are required for notification? And then really they have to be able to coordinate across providers that may not otherwise have to interact, whereby, they're separate pieces, separate offices, and there may be an entity that coordinates, but it may not be the provider that is going to be responsible for giving that good faith estimate. So I just think the process is going to be messy, certainly at first. And I think it's going to take time for these things to be kind of put into place in a way that is kind of smooth for getting the information to the individuals. And this is just for the people who don't have insurance. As we said, there's a deferral. It's not applying at this point for people who do have insurance and who are billing that insurance. I think that adds just, much more complexity.
Great. Thank you. And Bob, I know you mentioned some of the issues when you were discussing labs. What other issues do you foresee with the good faith estimate requirement?
Yeah, so as providers and facilities start to deal with their information management systems and trying to figure out how they're going to modify them in order to allow compliance with the good faith estimate requirements, I think a lot of the issues are starting to really come into sharp focus. I think ancillary service providers are going to be particularly challenged to comply with the good faith estimate requirements of the Act, because patients that come to them and either request a good faith estimate or schedule a service with them very frequently cannot convey enough information to the provider to allow it to give all of the required elements of the good faith estimate, particularly even the most core element of the disclosure, which is the price of the service. And let me sort of put this in context. For instance, if a patient goes to a doctor's office and they leave with a test order for let's say a radiology study or a clinical lab test, a lot of times those orders are not something that will be very easy for the patient to understand as a layperson. It might make sense to the diagnostic imaging center when it gets there, or to the patient service center of a laboratory when the patient shows up. But when the patient goes to schedule the request, not only is the patient going to have to be able to convey to the provider that they are uninsured or a self-pay, but they're going to have to give, in many instances, the provider enough information about the test that's being scheduled or the request that's being made for a relevant test to allow the provider to understand what the test is and then provide the patient with the appropriate good faith estimate. Some clinical labs perform thousands and thousands and thousands of tests, many of which are very, very similar to each other, have slightly different components. Same thing with diagnostic imaging studies. I mean, a CT of one shoulder is not always a CT of one shoulder. There's nuances there, and the prices can be materially different. Ancillary service providers are going to be relying heavily on lay patients to be able to tell them what they need to know about the test that they're going to get when they show up after scheduling it or requesting a GFE. I just think that's going to be a really, really difficult problem, again, for ancillary service providers.
Thanks, Bob. And does the good faith estimate provision impose any other requirements on the provider or facility?
Yeah, so like the billing rights disclosures of the No Surprises Act, there is a public disclosure that has to be made regarding patients' general rights to receive a good faith estimate that's imposed by the No Surprises Act. And what I mean specifically here is that providers and facilities that offer services to patients that are either scheduled or in instances where a patient could request a good faith estimate from a provider or a facility, those providers or facilities have to post on their website a notice that informs patients that they have a right to obtain a good faith estimate from them and how they go about doing that. In addition to the web-based disclosure, there's another form of public disclosure associated with the GFE that is similar, again, to the billing rights disclosures that are required by the No Surprises Act. And that is that facilities or providers that are providing services subject to the good faith estimate requirements have to post at a location where they see patients a notice that describes the general rights of the patients to receive a good faith estimate, either upon request or when they schedule a service. So again, there are these sort of two forms of, of public-facing, non-patient specific disclosures that have to be made under the No Surprises Act relating to good faith estimate rights.
Great. Thanks, Bob. Now let's turn to the patient-provider dispute process, which is another layer of patient protections the NSA creates. As we mentioned earlier, uninsured and self-pay patients who have received a good faith estimate of expected charges from a provider or facility may seek a determination from a certified dispute resolution entity if the provider or facility's bill charges are substantially in excess of the estimate. Now, the term substantially in excess was used but not defined in the statutory language of the NSA, leading many to wonder what substantially in excess means. The second IFR provided a bit more clarity on the issue. Bob, what does substantially in excess mean?
It's one of the few questions you could ask that's got a relatively easy answer, and it means $400. The amount was specifically identified in the IFR, and it's a bit strange because it is an amount, fixed amount, as opposed to a percentage of the cost of the test that's provided in the GFE. So the answer is $400 as of right now.
And I wanted to note also that while the patient-provider dispute resolution process is pending, the provider or facility may not move the bill for the disputed item into collection or threaten to move it into collection. And if they have already moved it into collection, they have to cease collection efforts. And the provider or facility is also prohibited from taking or threatening to take any type of retributive action against the individual for using the patient-provider dispute process. So those are just some preliminary items. But could you explain how the process is initiated?
Yeah, it's going to be an administrative process essentially, and the CMS website is going to have some information on it that explains how it can be invoked. There's sort of a statute of limitations element for a patient invoking his or her rights under the No Surprises Act when he or she believes that they've been charged for substantially more than the amount provided to them in the good faith estimate. And that is that they have to make their complaint within 120 days of receiving the first bill for the service. So the clock starts ticking, and it's roughly 4 months. So they've got a pretty decent amount of time to make a claim. I believe that there's going to be a form that's available on the CMS website. When it becomes operative, there's going to be a place identified for the patient to send the form, and there's going to be a $25 filing fee associated with the filing. And I believe that the patient also has to include a copy of their good faith estimate along with the complaint form that they submit to the regulatory agencies when they invoke the dispute resolution process.
Great, thanks. And Helaine, could you describe a little bit more of what information needs to be included in the notice to initiate the patient-provider dispute resolution process and sort of the process that happens once HHS receives the notification?
Sure. And for those of you who listen to our podcast on the IDR process, the dispute resolution between the provider and the plan, it's kind of similar. The notice for the patient-provider dispute resolution process really has to have enough information to identify the item or the service that's subject to the dispute. So that would include the date that the item or service was provided, a description, a copy of the bill that the individual received from the provider or the facility, a copy of the good faith estimate that they received. Also, that could be a photocopy or some kind of an electronic image. If not included in the good faith estimate, if there's some aspect of, let's say, a service that perhaps wasn't included, then you would have to include contact information for the provider or facility that was involved, identify the state where the items or services were furnished, and also really how the individual who's filing the dispute would want to be communicated with, what's their communication preference. So that could be paper, standard printed mail, electronic communication, or through the IDR portal, which again, for those who heard our prior podcast, is a system that the HHS has developed to use for both the provider plan dispute resolution process and the individual provider dispute resolution process. So what happens once the process is initiated, and again, similar to how the provider plan process works, HHS assigns a dispute resolution entity, and these are separate from the entities that are hearing the provider plan disputes, and there are probably going to be fewer of them. I believe they said approximately 3 was the expectation, but HHS will assign one of these dispute resolution entities that's been certified to conduct the resolution. They have to make sure there's no conflict of interest that they have with respect to the provider or the patient. They have to notify the provider or facility that there is a dispute that's been filed. They have to send an initiation notice. So they have to review everything. So again, similar to the other process, does this meet the requirements to be reviewed under this dispute resolution process? And does it have all the information that's required to assess that dispute and render a determination? It's similar, 30 business days to review. And if the dispute resolution entity determines that the subject, the item or service meets the eligibility criteria and they've got the information that they need, then they will move forward and have to decide what number is the right number.
Thanks, Helaine. And how must the SDR entities determine the payment amount?
The SDR entity has to review any documentation that's submitted by either the patient, the uninsured or self-pay person, and also submitted by the provider or facility. So they first have to look at that information, decide whether the information is credible and whether it demonstrates a difference between what was the billed charge and what was the expected charge that was included in the good faith estimate. And really, were these unforeseen circumstances? So do the additional charges relate to unforeseen circumstances that really could not have been anticipated by the provider or facility when the good faith estimate was provided? That they couldn't have anticipated that these extra costs would have been there. So it doesn't invalidate the charge or invalidate the good faith estimate. So credible information means really that they have to critically analyze, it's worthy of belief and trustworthy. So ultimately, what the entity has to decide and what they look to for items or services that are appearing on the good faith estimate, if the billed charge is equal to or less than the expected charge for the item or service, then the dispute resolution entity must determine that the amount to be paid for the item or service is the billed charge. So if it's equal to or less than the expected charge. If the billed charge is greater than the amount in the good faith estimate, and the dispute resolution entity determines that the information submitted by the provider or facility is not credible, it doesn't provide credible information that the difference is unforeseen and couldn't have been anticipated, then the dispute resolution entity has to determine that the amount to be paid is the amount in the good faith estimate, because they're saying that the provider or facility didn't support their argument that we couldn't have known about these charges, so therefore it wasn't included in the good faith estimate. So they've not borne that burden. And finally, if the billed charge is greater than the amount provided in the good faith estimate, but the provider or facility does provide credible information that they couldn't have anticipated that the additional costs would occur, and they couldn't reasonably foreseen that, then the entity has to determine that the payment amount should be either that billed charge or the median payment amount. Ultimately, if the dispute resolution entity finds that the information provided by the provider or facility does show that they have a credible argument that they couldn't have anticipated the additional charges, and therefore that's why they weren't included in the good faith estimate, and it doesn't invalidate that estimate, ultimately the dispute resolution entity would have to select as the amount to be paid the lesser of the billed charge or the median payment amount paid by a plan or issuer for the same or similar service by a same or similar provider in the geographic area where the services are provided, and they would get that from an independent database. It's a complicated process to go through, again, similar to the provider plan process that we've talked about previously.
Great. And what happens after the determination?
So the determination is binding upon the parties unless there's some showing of fraud or misrepresentation in the information that was submitted and reviewed by the dispute resolution entity. But there's still the ability for the provider or facility to kind of negotiate or come to an agreement with the patient, either to accept an amount lower than what it was that the dispute resolution entity determined, or that the provider or facility could arrange for some sort of financial assistance or payment arrangement, with the individual. So there is still some flexibility there.
And what are the costs associated with the patient-provider dispute resolution process?
So the costs really are administrative fees, and they go to the department. They get remitted to HHS. And if the provider or facility loses, they have to pay an amount equal to that administrative fee to that individual, the uninsured or self-pay individual, in the form of a reduction in the payment of the amount that the individual owes, that final determination that the dispute resolution entity makes. In the case of a settlement, it's sort of half and half. In the event that the individual does not win, then the individual will themselves have to bear the cost of the process.
And in line with some of our previous podcasts, I also wanted to note that there's an interaction between state law and the federal patient-provider dispute process. In the interim final rules, HHS described that if HHS determines that a state law provides a process to determine the amount to be paid by an uninsured or self-pay individual to a provider facility, and that process meets or exceeds the federal process, the secretary will defer to the state process. So this HHS will review the state process and determine whether it meets or exceeds the minimum federal requirements set forth by the NSA, and HHS will communicate to the state whether or not their process meets these requirements, and will notify the state of the determination. So Helaine and Bob, thank you again for your insight as we went through the good faith estimate portion of the NSA and how that'll impact providers and facilities, not only those subject to the NSA's balanced billing prohibitions, but also more providers and facilities generally. Thanks to the listeners for tuning in to this episode of Diagnosing Health Care. If you found this episode interesting, please look out for additional coverage on the NSA from Epstein, Becker, Green. If you enjoyed today's podcast, please subscribe to the show. Diagnosing Health Care is available wherever you get your podcasts.
Thank you for listening to Diagnosing Health Care. For show notes on today's episode, additional episodes, and more insights on trending issues in healthcare, please visit diagnosinghealthcare.com and be sure to subscribe on your preferred platform. The Employment Law This Week and Diagnosing Healthcare podcasts are presented by Epstein, Becker, and Green, PC. All rights are reserved. This audio recording includes information about legal issues and legal developments. Such materials are for informational purposes only and may not reflect the most current legal developments. These informational materials are not intended and should not be taken as legal advice on any particular set of facts or circumstances, and these materials are not a substitute for the advice of competent counsel. The content reflects the personal views and opinions of the participants. No attorney-client relationship has been created by this audio recording. This audio recording may be considered attorney advertising in some jurisdictions under the applicable law and ethical rules. The determination of the need for legal services and the choice of a lawyer are extremely important decisions and should not be based solely upon advertisements or self-proclaimed expertise. No representation is made that the quality of the legal services to be performed is greater than the quality of legal services performed by other lawyers.